Can someone be charged with possession of a stolen vehicle when they weren't possessing it at the time they were arrested? I'm Tulsa Attorney James Wirth, and that's the question that we have. First off, there's a lot of different names that we're familiar with for crimes, whether that's grand theft auto or possession of a stolen vehicle. But not every jurisdiction has the same names for crimes or even the same requirements for proof. So if you are in possession of a stolen vehicle, there's a number of ways that it could be charged. Obviously, if you were the one that stole the vehicle, it could be larceny of an automobile, grand larceny. If you are not the one that stole the vehicle and you're simply in possession, it could be joyriding that it's charged. But a common one that we see that may be most similar to what you're talking about as far as possession of a stolen vehicle might just be what we call knowingly concealing stolen property, or KCSP. And what that requires is that there was a concealing, withholding of the property stolen from the owner, and that the person possessing it knows it to have been stolen and that they had the intent to deprive the owner. Those are the elements that you have to prove. So for your question, it's if you were not found by law enforcement to be in possession of it, you weren't arrested at that moment, can they still prove those elements? So it's not necessarily a question you're asking about what the crime is. It's a question of whether they can prove the crime. Most of the time for these type of offenses, law enforcement found the person in possession of it. That's the evidence that they have, is that law enforcement person's, they may have video as well, but mostly it's going to be testimony. So in the circumstance you're talking about, that didn't happen. You weren't in possession of it at the time that you were arrested. That takes away the most important evidence that is normally presented by the state. Does that mean that they can't prosecute it? No. But it may mean they may not have sufficient evidence to prosecute it. If they still have excellent evidence beside that fact to establish each one of these elements, then they could prosecute you and you could be convicted beyond a reasonable doubt if the judge or jury believe that. So it's not about whether they are allowed to, they are. It's whether they can meet their burden of proof. And the fact that they didn't catch you in the act means it may be more difficult and it may be impossible, in fact, for them to meet their burden of proof, but it doesn't mean they're prohibited from bringing the charge. It just simply means they may not have as much evidence as they otherwise would. If you're dealing with a circumstance like this, a criminal investigation, or you're being prosecuted, you're going to want to talk to an attorney privately and confidentially about your circumstances to make sure that you receive legal advice that is best for you. To get an appointment scheduled with an attorney at my office, you can go online to makelawEasy.com.